Hello there once again, and welcome to The Verdict. Mick Cornett and Kent Myers, we're here every week meeting interesting people and dealing with topical issues, and we're glad you've chosen to join us today.
Today, we're going to talk about something that has perplexed me for many years. I won't tell you how many, but I've been practicing law a long time, and I know that the vast preponderance of cases get settled, and some of them, I don't see how in the world they ever get settled, but they do. So today, we're going to have a show on how a case is settled. And we're going to have two guests that have settled hundreds, if not thousands of them, and are the best in the business. Tell us what tricks of the trade they use to get recalcitrant lawyers like me to agree to a settlement.
Sounds like a good show. We'll be right back. You're watching The Verdict.
Well, prices at the pump are hitting new highs this week. In other news,
gasoline is expected to top $4 a gallon this
we
week.
expect drivers seeing sticker shock at the pump.
OPEC has raised the price of oil again, and Wall Street worries.
Well, a full tank of gas is going to set drivers back.
Straight ahead, the latest news on
Wilsey, Meyer, Eatman, Tate. We're accountants. We do taxes, business valuations, estate planning, and consulting. And we're right here in Oklahoma, working with the owners of small and medium-sized businesses. Steve Wilsey and Stuart Meyer have the resources and the experience. Wilsey, Meyer, Eatman, Tate in Oklahoma City and Tulsa.
Welcome back to the set of The Verdict. Mick Cornett with Kent Myers. Kent's going to introduce today's guest.
Today, we're really pleased to have a couple of folks that know a lot about settling cases. They do it all the time and do it in all kinds of cases. To my right is the Honorable Lane Wilson. He is the U.S. Magistrate, one of the U.S. Magistrates in the Northern District of Oklahoma in the Tulsa area. He did his undergraduate work at Tulsa University, did his law work at Tulsa University, was in private practice in the Tulsa area with the Hall Estel firm, a fine firm over there, for about 15 years. Has been a U.S. Magistrate now for 3 years. He's married with 3 kids. This is his first visit to the Verdict. Judge, sure glad to have you.
Thank you for having me.
On the left is a former law partner of mine and a friend, a current friend, not former friend, Steve Barghols. Steve is an attorney with Gable Getwals law firm in Oklahoma, has offices in both Tulsa and Oklahoma City. He did his undergraduate work at the University of Oklahoma, his law work at the University of Texas. He has been in private practice for 35 years and counting. He won't agree with this, and that's okay, but he's known, at least in the Oklahoma City legal community, as the premier mediator, settlement guy in the jurisdiction, and he's everybody's first choice for a mediator. He settles a lot of cases, and he's a former president of the Oklahoma County Bar Association, along with a lot of other honors. Steve, glad to have you.
Thank you, Ken.
All right, Judge, let's start with the first process. When you learned you're taking a case, how does that process start?
Well, we send out a settlement conference order to all the parties, and that order sets out sort of what they're expected to do before the settlement conference, what they're expected to do and who they're expected to bring to the settlement conference. When I get assigned a case, it's sort of a decision made by one of the other magistrate judges there, Judge Paul Cleary. We have a very, very active settlement program in the Northern District, and so we use a lot of local attorneys as well that provide their settlement services sort of free of charge. But when I get assigned a case, we send out an order telling the parties when they need to submit a statement to me, when they need to appear, and sort of what they can expect from the process.
Safe to say that your preference is that this is settled before you have to deal with it?
Well, it is. I mean, in the Northern District, I think that usually is not the case if it gets assigned to me. Usually, it does not settle before I actually hold a settlement conference. It will occasionally through the work of somebody like Steve, oftentimes.
In the course of a year, just approximately how many different cases will you be assigned to try to settle?
I'll probably be assigned somewhere in the neighborhood of 35 to 40. I'll probably actually conduct around 20 settlement conferences for the very reason that you said, Mick. Oftentimes, when they see that order come out, they know they're going to have to get serious about settlement. So whether through someone like Steve or on their own, they do oftentimes settle before it gets to me.
How do you ensure that everybody that's supposed to be there is there? I mean, if the parties show up, you're ready to go, and some important person is not there, what action do you take and can you take?
Well, I've got the benefit of the robe and a court order, and so that does not happen too often. Occasionally somebody will show up that either does not have authority to settle the case or is somebody who really isn't there really with knowledge of the facts, and we have a variety of ways of dealing with that. Sometimes we'll try to get somebody on the phone. More often than not, and it may sound a little draconian, but it is what we do, more often than not, we'll just reset the settlement conference and sometimes require the party that didn't come with the person who should have been there to pay for the other side to show up next time around.
Well, for instance, if the city of Tulsa gets sued, you don't require the mayor to be there, I take it?
That's correct. With the city of Tulsa, we would require somebody with the appropriate settlement authority, and so they obviously have to do their homework before they get there. With large corporations and even some small corporations, you can't require the CEO to come in, and so again, it will be somebody with settlement authority up to a certain level.
Steve, let me direct kind of the same line of questions to you. In the course of a year, approximately how many cases would you look at and try to mediate a settlement?
I'm averaging approximately 225 cases a year now.
Wow.
Every conceivable discipline, commercial litigation, business problems, employment, real estate, contracts, but also a lot of personal injury, wrongful death, products liability, just about the whole gambit of civil litigation.
And when the parties come to you, they aren't assigned to you necessarily, although I guess they could be.
Quite often, the trial judge has required that they mediate before the pretrial conference will be set.
But they can pick the mediator.
No, the parties pick the mediator.
Yes.
The judge does not pick the mediators.
Yeah.
Steve, are there a small number of cases in which the client has something beyond a settlement in mind? I mean, they want to prove a point or there's a principle involved.
Right. Those are probably the most challenging mediations I encounter. Sometimes people are mad. Sometimes they say it's not the money, it's the principle.
Yeah, what do you do
Of course,
then?
principle can be spelled P-L-E and P-A-L. But we run into that quite often. Sometimes there's a disparity in the economic resources of the parties. I see that most often in employment and also in family dissolutions and business dissolutions, where somebody wants to teach the other side a lesson and they don't have any intention of settling.
Well, Judge, you probably run into that same sort of thing.
I run into that all the time, and I usually try right up front to let the parties know that a lawsuit, in my view, in my experience, is not a place to prove a point. Oftentimes, when they do go try the case, when they get to the end of that trial, even if they win, they don't feel as good as they think they're going to feel when they get to that point. And so I try to really drive that home to them initially, to let them know that this really isn't the setting to try to establish some kind of emotional win over the other side.
So they may feel better, but if they're looking for closure from the result of this law action, they're probably wishful thinking.
I think that's exactly right.
They don't have a settlement remedy that they get to whip the other side or anything like that, like they may feel like doing.
Well, that's very true. You know, even if you're a plaintiff in the case and you happen to get a good verdict at the end of the day, well, you're usually going to sit on another 18 months to 2 years of appeals. And then if you don't win that appeal, you're right back where you started. And so it may give them initially a good feeling, but it's like you said, it doesn't give them the kind of emotional closure that they oftentimes think it will. When
we opened the show, I was telling Mick that the vast majority of cases that are filed, in my experience, settle. They don't go to trial. Not near as many of them go to trial today as perhaps used to years ago. Steve, if you can, just a ballpark estimate of in this jurisdiction in Oklahoma City, how many cases settle?
I don't have any statistics from the state courts, but I do have them from the federal courts because those are published each year. And I looked over the weekend just to see, for instance, in the Western District, United States District Court for the Western District of Oklahoma, here in Oklahoma City, that handles cases across the western part of the state. At the end of the fiscal year 2011, there were approximately 1,500 civil cases pending. And I noticed that there were only 15 jury trials in those civil cases last year in the whole district.
Wow.
And so that shows you it's about, 1% actually goes to trial. Now the other cases, they can wash out on summary judgment or motions to dismiss, or, but many of them settle.
But 1% goes to trial typically. What's your experience?
It's very similar, very similar. Same numbers in the Northern District, I believe.
And how long would a typical trial last, Judge?
I think most trials are probably about 1 week, maybe a little bit less. It's not the length of the trial, I think, that discourages people from trying the cases. It's the fear of the uncertainty, I think, more than anything else.
Yeah. You're rolling the dice at that point.
You really are. You really are. You never know what a jury's going to do. I tell every party in front of me that if you have the best case in the world, if it's a slam dunk, you've got an 80% chance of winning.
All right, Judge T. Lane Wilson with Steve Barghols, today's guest on The Verdict. We'll be right back with another segment.
The thing that has made the most sense for me is realizing that I am still an educator, and that is what I do at the Chickasaw Nation. I'm Dr. Amanda Cobb-Greetham. I'm a historian, and I'm Chickasaw. The Chickasaw Cultural Center is amazing. It is a very, very special place devoted to the sharing and to the celebration of Chickasaw history and culture. State-of-the-art technology, exhibits that are not like anything I've ever seen. The Spirit Forest is incredible, and you feel as if you have actually just walked into a forest with huge trees all around you. It's timeless, and yet it's sort of also representative of our time depth, to really just sort of reach through time and touch the past. By the end of the exhibits, you really have a sense of Chickasaw cultural and political resurgence, and the extent to which we are a healthy, dynamic, and vital tribe today. Chickasaws have always been an inclusive people. This is something for the whole community and for the state of Oklahoma.
I don't want to hope for the best. I want to become it. I want you to see my potential.
Because I can be more than average. I can be amazing.
Because I know the hard way
and the right way
are one and the same.
I will make you proud.
And surpass even my own expectations.
I will lead.
I will lead.
I will lead America's energy future.
Oklahoma's oil and natural gas industry. Proud to equip Oklahoma students for greatness.
When you have something important to communicate, it becomes clear that there's a lot of competition for your audience's attention. So how can your message stand out and actually resonate with your audience? Legal Graphics has the answers. The team at Legal Graphics will work with you to plan, design, and even test your presentation to ensure your message will be heard and remembered. Call Legal Graphics today to schedule an appointment. The readiness is all.
Welcome back to the set of The Verdict. Steve, when we left, we were going to try and pin you down on, what's the strategies for getting parties to come together to try and get some sort of matter resolved?
Well, Mayor, I wish I could make it sound complicated and exotic like rocket science or neurosurgery, but it's pretty simple. I have 3 strategies. I want the parties and counsel to identify the risks, evaluate the risks, and manage the risks. Judge Wilson mentioned the uncertainty.
Risk being risk of trial.
The risk of litigation and the risk of trial. A lot of cases don't even get to trial because of risk.
Do you also want them to verbalize what it is you're trying to achieve?
Certainly, and that's part of the process. It's cathartic for the parties, the principals, to be able to tell the neutral, the person who has a clear head and a cold heart, who's absolutely objective and neutral, why he or she thinks that we're at the mediation. So that's very important to vent and have that opportunity, because before then they've only had a chance to tell their lawyer how badly they've been treated.
Judge, what's your response to that same thing?
Many of the same things that Steve just said. I mean, I make a real effort. Oftentimes we only have 3 or 4 hours to try to get the mediation done over in the courthouse. If that's the case, I make a real effort the first hour to try to get to know the parties, try to figure out exactly why it is they're there, and oftentimes it's not for the reason that you would find in the pleadings. It's for some other reason. If you can get to the bottom of that, you can oftentimes get them to a point where they're willing to consider settling the case.
Steve, let me ask you this. You are well known in the practicing law community as being a mediator that won't keep you there when it's useless to keep folks at a mediation. Now, let them go if it's going to be impossible. But how do you know? What do you look at to determine whether or not this is a waste of time, these parties are not going to settle? I suspect most people would give you that impression at the beginning, and yet they end up settling.
Well, I do have a conscience about it. I pride myself on my conscience. You've worked with me before. You know that I used to bale hay for $1 and worked on the freight docks, and so I know it's an expensive process.
That's when he was an associate with our law firm.
That's right. And it's a stressful process. They've spent a lot of money to get there, and so I watch the entire process to make sure they're serious, that they are willing to concede that there is at least one degree of risk in their position, and if they are there just to put in their time and have their card punched, then I send them home. On the other hand, if they're willing to work with me, if they are willing, both sides, to acknowledge there's risk and willing to manage that risk, I've had mediations that have lasted 14, 16, 20 hours, and I am persistent.
Let me back up a moment. I don't think we got to how a mediator is chosen. Do both sides come together to choose a mediator, or is the mediator assigned?
The mediator is selected by counsel, which is sometimes a challenging process.
Yeah, what if they can't even decide on a mediator? Does that happen?
The court sometimes will help them find a mediator. I don't think the court ever orders a mediator, but the court will help sometimes make recommendations, which is tantamount to a...
Do mediators typically have a specialty?
There are a lot of mediators who specialize in family law or in employment law, but most mediators that I know have a general practice. Subject matter knowledge is useful, but it's not imperative to be a competent mediator.
Mm-hmm. And you were mentioning earlier to try and get the two sides to be flexible. And is part of that strategy to allow them to understand this may not go the way they want it to go if they continue to pursue this hard line?
Correct. Keep in mind that when we do these mediations, we have the parties in separate rooms. And so it's the first time sometimes that the parties and their lawyers have had an opportunity to explore the downside of the litigation as opposed to the upside. And it's occasional that a party will find out for the first time that they don't have a slam dunk, that there's a 50% chance they'll never get to a trial, that if they lose the case, they'll have to pay the other side's legal fees and expenses. And so it can be very humbling and very eye-opening for some of these principals to come in and find out that there is downside to their position.
I want to ask you, Judge, kind of the same question. A lot of times the first time you see the parties will be the first time, as Steve has said, that they're here, that they may not have a slam dunk. Their lawyers may be saying, we got this in the bag. It's only going to take another year of getting ready for trial and then have a 6-week trial.
Sure.
But we're going to win. Of course, a lot of bumps in the road between those two time periods. How do you get the parties over that sort of erroneous assumption?
Well, you know, my background's engineering before I went to law school, and so I grew up being a problem solver, and so I tend to kind of poke and prod until I find an area where I find some sort of vulnerability, where they can acknowledge, as Steve just said, they at least have a 1% chance of losing, and if you can find that, then oftentimes you can get them to realize it's even worse than maybe they think it's going to be. But again, I find that it's really important for me to establish a relationship with the parties, because if I can do that, I do get some experience to draw on as a judge, that oftentimes a party, when they hear it from somebody like me who doesn't have any sort of a dog in the fight, they're willing to maybe take a different look at it. Now, the advantage Steve has is he is selected by the parties, as he said. I'm not selected by the parties. And so I think in some sense I have to work a little bit harder at building trust, because they just get assigned to me.
I noticed in the course of one settlement conference in your court, I was pleased to attend. When you came in, everybody jumped up, and you didn't even have your robe on. You didn't have a suit jacket on. You've dressed up to come to the verdict. I have. You had a shirt and tie on, and you came in, and you were very easygoing and told everybody to sit down and not worry about it. And a number of the folks in my party commented on that and how that did make them feel at ease. Is that why you do that way?
That's exactly why I do that. You've got to feel like you're in an open environment, where you can actually share. One of the provisions of our confidentiality of our order is that there is confidentiality in the settlement agreement. Well, you can tell parties that, but you need to make them feel that as well. But that's exactly why I don't wear my robe or I don't wear my suit jacket oftentimes, because I want to have a real conversation with the parties.
Judge, you can't be an expert on everything. And just sometimes you have to rely on the expertise, the specialty of the mediator to kind of help you understand the complexities?
Well, oftentimes I have to rely on the expertise of the various attorneys. I mean, you can kind of come up to speed as much as you can beforehand. I probably spend 2-3 hours before I go into a settlement conference. Now, Kent, in the case you mentioned, it was more a matter of days in that case. I think I set a record on that case in terms of how long it took. But yeah, because we don't have time, as I think Steve mentioned, to get fully up to speed on all the issues, especially if it's a complex patent case or something of that sort.
Well, I'm glad you brought up that, because with technology driving more and more litigious situations, and the technology, the complexities that come out of the patents, and there are sides that just claim to have a position in the case. How do you deal with that and when something like that's so fairly new?
Well, I spent 15 years of my career cross-examining people in depositions, and so you can do it in a way that doesn't offend them. You can do it in a way where you don't get in their face, and if you learn to ask the right questions, oftentimes even if you don't know the subject matter and they do, you can get them to realize maybe weaknesses that they wouldn't otherwise acknowledge.
Steve, you were and still are a successful practitioner for a number of years, but you kind of we just have about a minute left, right. So we'll have to be kind of careful about that. But what skills did you develop, or do you have, or should a mediator have to be able to do the job well?
I think the first skill is you have to be neutral, perceived and actual as neutral. You can't lean in either direction. You can be empathetic and compassionate to people without losing your neutrality, but you have to be perceived as being right down the line and not leaning to the insurance company, for instance, or the injured plaintiff. You have to be prepared for these mediations. Judge Wilson mentioned that there is a fair amount of preparation time that is involved. You have to understand the who, what, where, when, why, and then you have to be persistent. You can't give up just because somebody grumbles.
All right. Hey, we appreciate you both coming on the verdict.
Thank you for having us.
It's a fascinating show.
Thank you very much.
Steve Barghols, Judge T. Wilson, our guest today on the verdict. Hope you learned something as well. Kent and I'll have a final minute when we get back.
The good life comes naturally to Tulsa, where nature's beauty is matched with an eye for aesthetics. A legacy of neighborhoods graced with lawns and landscaping and handsome homes. A place that seems to have patented an ideal lifestyle. Bank First is loyal to the quality of life Tulsa assures its citizens, to the priority placed on education, culture, and growth. Loyal to builders who transform raw land into residential charm. Developers who see opportunity and add vitality to Tulsa's economy. Bank First serves both enterprise and private lives that need a loyal partner. It's how we help nurture this city's very good life. Bank First. Loyal to Oklahoma. Loyal to you.
In Oklahoma, we enjoy a high quality of life due to good, well-paying jobs. Commercial real estate professionals play a significant role in bringing new businesses and investments to Oklahoma. The commercial real estate community has come together to market Oklahoma's commercial properties nationwide through a free public website, okcommercialproperty.com. We are invested in keeping Oklahoma strong and growing because economic development ensures quality of life.
You will always be Mom and Dad to me.
We lived on a family farm. We didn't have other families that lived close to us.
Right.
And we wanted our kids to grow up being friends. You know? And so when they did grow up and disperse, it wasn't hard to acclimate to other parts of society or being a friend.
You will always be Mom and Dad to me.
The Journal-Record is pleased to be a sponsor of The Verdict. The Journal-Record, since 1903, the best source of Oklahoma business news and legal information. And for almost 30 years, Oklahoma political, government, and business leaders have turned to the McCarville Report for accurate, reliable, inside information. Visit the McCarville Report online.
Welcome back to the set of The Verdict. That was an interesting show.
Well, I thought it was. I found out some of the trade secrets of these fellows that have been making life miserable for me for a number of years. They get things done when nobody else thinks they can, and oftentimes when others have tried and failed.
Yeah.
And I wanted our viewers to have a chance to see the best.
Yeah, it really is. It shows, you know, that you sometimes just have to kind of take the edge off the issue and make the client or the attorney, you know, really open their eyes to what the true facts are.
Well, I have seen some very innovative techniques involved where cases you just know can't settle do, and I never know why, but now I think we have a little better idea after today.
Well, it was an interesting show, and we'd love for you to go to our website and tell us about a topic you'd like to see discussed on a future edition of The Verdict. Do that by going to the website at theverdict.tv. That's theverdict.tv. You'll see all sorts of interesting information about the show there, and again, allow us to have an idea of what you'd like to see on a future edition. That's going to do it for today's show. We appreciate Judge and Steve Barghols for coming in. It's fascinating to get to meet both of them. Yeah. For Kent Myers, I'm Mick Cornett. We will see you next week right here on another edition of The Verdict.
The preceding program was produced exclusively for the Cox Channel.